Today's question comes from Charles in Okemos. And Charles says that I received a quitclaim deed from a seller who says that she received her rights to sell her rental property from her now deceased husband. It was previously owned by her husband and his father. The problem is that both her husband and her father-in-law, his father, have the same name, except there is no senior, there is no junior, or any other indicators in the name to distinguish one man from the other. Another wrinkle here is that both men used as their address on the deed the rental property address. Also, there is no language on the deed that says how the interests in the rental home were held. No survivorship language. Now the father-in-law says that this lady has no rights to the property, that the name of the signer on the deed is not his signature, and he did not give her a deed, so she could not have sold the property to me. Is he right?
Wow. Okay.
That's a bit tangled.
Yeah, it's a little tangled, and we're used to it. So in general, Blair, like when people have issues like this, I'm a highly visual individual. Like I'm very visually oriented. And so I always say you know what I say, I need to see the documents, right? This happens. Okay. So what I hear is there's a lot of confusion because of the names, and the names are the same because honestly, you don't do your family a service when you don't use senior or junior and or the first or the second or the third. You have to, when we're dealing with drafting a document, when you have issues like that, especially with joint owners, you really need to distinguish them. Now, here's the thing, and I heard it, like the minute I heard it, I'm like, oh, good. Even though both parties have the same name and the same address, we both know that the father and the son were on the deed. And if she was married to the son who has the same name as his father and you can't distinguish it, it doesn't really matter. The reason why this is an important fact pattern is I hear that there's no joint with right of survivorship language. In fact, when nothing is stated there, in a deed, you have to have magic language. And the magic language trips people up a lot, okay? And with all due respect, I make a very nice living off of cleaning up legal messes related to people failing to use magic language. But when we don't have joint with right of survivorship, the law will automatically assume that these people are not joint tenants, but tenants in common. Okay, that's number one. Number two, if this lady was married, okay, to the son who passed away, at the time he passed away, if they were married, if the son did not have a will, his interest needs to be probated. This lady would have had to probate his interest, okay? But she most likely would be the person who would be the divisee, the person who receives the property, okay? 50% of it. The other 50% belongs to the father, okay? I mean, I'm kind of like working without a net here because I don't see the document. So, anything that we do, it's just, it's pure speculation. It's not taken for legal advice. It's just to, for entertainment purposes right now. Right. But what we'll do is assume that she has to probate the property. So she has to first get the title into her name. She has to probate her deceased husband's interest, and then she becomes the joint owner with her father-in-law. Okay. Now, this is a great file, actually. I mean, to me, the fact that the father, I don't know, he's using the confusion to say, well, I didn't sign it off or whatever. It doesn't really matter. If there were tenants in common during the lifetime of her husband, now deceased husband, he still would have been able to give his 50% away. And if the father is able to hold on to his 50% and says that he's never deeded it out, the only way that these parties are going to be able to resolve their issue is once this lady gets the property into her name, or the 50% interest of her deceased husband into her name, okay? And if her father-in-law doesn't want to work with her, they'll have to now go to court, and we get a declaratory action. We ask the court for a judgment that splits the property in half, causes both parties to sell the property and split the proceeds. Okay. And do you remember, Blair, we were talking a while ago about what happens when parties don't agree to how much contribution somebody should be entitled to when it comes to repairs or advances for property taxes or insurance, and they're just 50-50 owners?
No, what?
They,
Oh.
the title company is going to split it 50-50.
Yes, right, the title company is then just going to.
Right, right. Unless the court gets involved and says, well, you know, there's certain fairness here that you should be entitled to receive some money back. So long and short, yes, the question is a little complicated, but when you get through all this, like the father and the son, it doesn't really matter. How did they hold title? That's what matters.
Right.
Okay. And the distraction is how they, you know, their names are, but it really is not of consequence. It's just how do they hold title? And that's your answer. They hold it 50-50. Okay. So that's it.
So the one issue that I have with this is not really an issue. It's just this person, the inquirer, said that they received a quitclaim deed from a seller.
Right.
And so that is to my knowledge. So I have never bought or sold a property on a quitclaim deed. I always go through a title company, and I always give and receive warranty deeds.
Right.
Because I need title pulled, because I need to know that the person who is selling me the property has the ability to sell me the property, so that something like this is a situation that I could easily, as a real estate investor. So just for context, for those who are listening,
Right. Sure.
You know, as a real estate investor, this is a scenario that I could easily get myself into if I were just using a quitclaim deed, because that's something that you could just do, like at the kitchen table with someone else, can't you? Like, can't you just sign the deed and sign it over?
People do it all the time. People do it all the time and mess up a lot of times.
Right.
Which is fine by me. I call it the gift that keeps on giving. I mean, I don't want, you know, I'd rather people don't have the stress or the problems, but if you're going to go, this is part of doing due diligence, and part of this due diligence would involve having title work. Okay.
Right.
But, you know, it's really important that you pointed it out. I was so focused on the ex-husband, the deceased husband and the lady who actually gave the deed. I forgot about the person who's actually doing the inquiry.
So the first time I ever bought or sold a property as an investor, I was very green on, you know, what's a warranty deed, what's a quitclaim deed, but I just knew enough to go through a title company. That's just how I knew to do it, and to ask for a warranty deed. That's just what I knew. And so learning later on, like, how quitclaim deeds work, you know, just for those who are watching, who are like, well, what's the big deal with a quitclaim deed? You really don't have any idea that you have the rights to purchase that home, or that the person who is deeding the property to you even has the rights to sell to you. It
just says, if I have whatever interest I may have in this property is what I have. It doesn't make any representation that there truly is an interest. It's, you know, I can give you a quitclaim deed right now for the Brooklyn Bridge. Okay. I could, and you could take it. Doesn't mean I have a right to it. So getting back to just that part, how does that person prevent, or how should they have prevented the problem for themselves? And that would have been hire an attorney to review the title. You pull the title, the attorney pulls the title. It's called an abstract. You can get it from a title company, but the title company cannot give any legal opinion.
Right.
Okay. They can only just say who they see in title currently. That is not something that they could actually give a legal opinion on. Right. Here's the thing. I hope that person ordered title work. It doesn't say, but it doesn't sound like they did. And I hope they didn't pay a lot for that property. But at the very least, they have a 50% interest in the property. Okay. That part, you know, they have, because the lady had a 50% interest in the property once she probates it. Okay. But you have to deal with the father-in-law. I mean, her father-in-law. Okay.
Sure. And not to get any more twisted, but so
twisted more.
Sure. So the lady sold it as though she had, so this person purchased 100% of a property. I'm sure
That's
they,
what they believe they did, right?
so I'm sure they paid,
Mhm.
let's just assume they paid full market values. Let's say they paid $100,000 for this property, but the lady only is entitled to $50,000. Would she
Right.
then have to give that other 50 to her father-in-law? What if it's gone? You know, what if that money is gone? Like, how does that
Problem.
work out for the person who purchased this property, who paid 100% of whatever the property was worth? I'm just assuming, you know.
Right.
So I'm just saying, how do you allocate the money that was given for the purchase?
I have 2 words for you. It's called due diligence.
Uh-huh.
He lost that money and he deserves it if he truly did not. If the scenario ends up the way it does, which I believe it will be, she only has a 50% interest.
Sure.
You know, he can't even like sue her because she's
Goodness.
saying, I'm giving you whatever I have.
Okay.
Okay. So that's where insurance comes in, you know, because maybe if they had title insurance, that would have, by the way, if there was title insurance on a matter like this would have popped up as a red flag right away.
Right.
But the thing is that, I mean, it gets to the, somebody asked me earlier today, Blair, and I don't want to go down another rabbit hole, but, you know, we do 2 things really well. We counsel people who come to us before they complete a transaction or when they're contemplating a transaction and they say, hey, what am I doing right or wrong? I need your help.
Yeah.
Okay.
Right.
That's prophylactic. That is real due diligence. That's what we want to do for people. It is not sexy. It's kind of boring from, you know, as an attorney, it's a little bit boring with all due respect, that type of work, but it's necessary work and it protects the client and they're entitled to that protection if I'm doing the due diligence to make sure that their financial exposure is completely reduced and any legal liability is completely taken off the table. Okay, that's my job. That's one thing that we do for clients. Okay, not sexy. The other part that we do, which we really love, attorneys love, well, most that I know like to clean up messes. So we're cleaning up, as I've said to you earlier, sometime in our conversations, we clean up legal vomit. And that legal vomit is, you know, to clean it up, it can be expensive. People come in every day and vomit all over my desk with their legal issues. And they say, I don't know what to do. Please help me. Please clean up the mess that they've created, or either knowingly or unknowingly. And the reason that is the case is because they didn't do the due diligence 9 times out of 10. So that's the other side of the work that we do. I'm happy to do it. I'm always happy to help people get their issue resolved. But from a financial reward side, it's much more financially rewarding for us to clean up after legal messes. Okay. But I would prefer, like this situation is truly a legal mess that was created because a person did not do their due diligence.
Right.
Okay. That's it. And it would have been really boring and probably I would have killed the deal. Had they come to us and we looked at the title, I probably would have said to that guy, you know what? You're not going to like this, but you know, you're going to thank me later. Don't do this deal until it gets resolved.
Right.
And by the way, a lot of these deals, I mean, this deal is not that uncommon. And what we do is we would give that legal advice to say, but here's how you handle it. We're going to do this and we're going to do this. So before you buy it, hold on to your 100 grand that, you know, that's in your example, but hold on to that 100 grand and let's figure out how we make this work for you. And then we reach out. This is the due diligence and reaching out to try and make a transaction work. I'm not a deal killer. I want people to be happy. I want them to get the property that they're looking for their family or for their investment. But you got to go through several hoops. And sometimes you can't jump through that last hoop. It just won't work. And that's when we have to give people the bad news. But they also save themselves $100,000.
Right.
That's it.
Oh, that one kind of hurts me.
Yeah, I mean, I'm sure, you know, it's not, yeah, it's unfortunate, but
Yep.
I mean, there's a way to get it resolved. It's just you're going to lose some money.
Right. Yikes.
Yeah.